This is WLBT Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes, and tonight we're going to be talking about anything. That's right. Tonight's show is Ask Us Anything, but that's okay because we've got some great attorneys tonight to help you answer, or at least get answers to your questions. How about that? Because they have the answers. Help me welcome to the show tonight, Miss Lorelei Harris from Porter and Maloof. How you doing?
Hey, Morgan, I'm doing great.
It's always good to see you.
Too. It's been a couple weeks since I've done one of these. I'm glad to be back.
Well, I tell you what, we have a lot to talk about because COVID has been kicking up and looks like it's not going anywhere. So let us just take a moment to also bring on board Harry McCumber from Morgan & Morgan. How you doing, Harry?
I'm doing fine. Good to see you guys. It's been a while.
It has been a while. We've got to make up for lost time tonight. How about that?
Absolutely. Let's do it.
All right. Now, usually we do start the show talking about an email question or something somebody might have on their mind, but I want to talk to the both of you and give you both an opportunity to tell us what has been going on with your court cases and how have you been handling life in this COVID generation that we're in right now. So, Lorelei, what's been going on with you?
You know, we were starting to see some of the courts opening back up. We are still doing a lot of Zoom depositions. I used to travel quite a bit for our talc and powder litigation. And so all of that is done via Zoom these days. And we're still doing it that way. And, we might keep doing it that way for a while to come. But some of the courts are opening back up now, I think with some spikes. It's possible that some of them, while they're going to try to stay open, I think they're probably going to start requiring more masks and maybe even vaccines. But our office, we're still open. We're fully vaccinated here, all of our attorneys and our staff, and we have lots of masks. And so we're open. If anybody wants to come in and meet, we're still taking meetings and doing intakes.
Now, is mask a requirement in your office if someone wants to come and see you, or can they just come in unmasked if they're vaccinated? How does that work?
So, in the very beginning, prior to us all getting vaccinated, we did ask everyone to wear a mask when they came in. And so, but now that we're all fully vaccinated ourselves, we kind of are giving a little leeway to what our clients feel comfortable with. Now, you have to remember, we do represent a lot of ill people. We represent a lot of people that have been affected by asbestos and silica, and so their breathing is not great. So we like to defer to them. If they want to wear their mask to be protected, okay. If the mask affects their breathing worse than it already is, then we try to stay 6 foot apart. We have a very large conference table that allows that.
Okay, good deal. Well, Harry, how are things over at Morgan & Morgan?
Pretty much the same thing. I've noticed there have been some state court jurisdictions that because of, as Lorelei said, some spikes have decided to put the civil matters kind of on the back burner for right now, and they're handling criminal only matters primarily. But we are open. For some reason, I've had a lot of mediations recently on some cases. So it's business as usual when we can do it. Again, taking depositions by Zoom, kind of like we're doing right here. That's been beneficial. So Zoom is taken off. I wish I had stock in them since all of this, but and there's other resources we've been using. But business as usual, same thing. Try to be there for the clients, make sure they're getting their medical treatment and that their cases are still going forward and not just sitting there and getting stale.
This is true. This is so important for a client, especially if they're looking for a new attorney. And I think it's a good time right now to interject that, Harry, if people wants to see you, if they want to consult with you, are your consultations free, mask or unmask? Can they call you, text you? How do they, what's the best way to do that?
Absolutely. Consultations are always free. I do a lot actually by telephone. We get walk-ins. Someone will just be in the area and want to come by. I'll meet with them personally, but it costs nothing to talk about the case, to see if there is a case, give, basically free advice. And then if we decide to take it, of course, we do a contingency contract, which means, we only get paid if we're successful in getting a recovery for the client. We can either do that by an out of court settlement, or if the case goes to trial, we get a judgment at the end of the case. but it costs nothing. I'm sure Lorelai's same way, to go ahead and just, meet with a lawyer, talk about, let us know what kind of case you have, whether or not we think we can help you. It's a good deal for the client, especially people who can't afford to pay for their own lawyer.
Okay. Well, on that note, let's get to our very first email question. It comes to us from Sean. Now, listen, nobody expected COVID to be around as long as it has, but Sean's question is, do you foresee another big wave of COVID cases slowing down the courts as much as it did in 2020?
So I don't know. I tell a lot of my clients this. I'm just an attorney. I certainly have zero medical education or background, and so I don't know in terms of another COVID spike. I think that COVID has slowed the courts down. As Harry mentioned, the criminal docket always has priority over the civil docket, which is obviously what we do primarily, and so there are times where it might take us a few months to get a hearing date. So we asked for a hearing date just this week in a Hinds County courtroom, and we were able to get that set for a date certain in November. So court's still happening and things are still moving, but maybe not within a week. Now maybe we're a month or two out.
Okay. Well, what about you, Harry? Any thoughts?
I think it'll be county by county in the state courts, depending upon how they're dealing with their local issues with COVID. But for the most part, the courts, they're in a tough position. They need to keep cases moving. But again, criminal matters do take precedence over the civil cases. But I just think it'll, in the future, as more people have either come down with COVID or get vaccinated, things like that. I know we have the variant out there, but I think, ultimately there'll be a time when COVID won't be as much of an issue as it is right now.
We're talking about anything. Ask Us Anything is the topic. I'm Morgan Dukes, and we'll be right back with more of Law Call.
WLBT Law Call with award-winning broadcaster Tamika Smith and personal injury attorneys Tim Porter of the Jackson law firm of Porter Maloof, called one of the winningest firms in the United States, and Jackson personal injury attorney Rocky Wilkins, recognized as Mississippi Trial Lawyer of the Year by the Mississippi Association for Justice. Plus guest attorneys from across the state. Your rights, your calls, live. WLBT Law Call.
And welcome back to Law Call, everybody. I'm Morgan Dukes, and tonight we're discussing anything. Ask Us Anything is our topic, and boy, do we have some good questions. And, it's kind of underlying COVID related, because COVID is indeed the topic of the season, if you will. And I have two great personal injury attorneys with us tonight to really get into it. Lorelei Harris of Porter and Maloof and Harry McCumber of Morgan and Morgan. So good to have you both with us. Now, this next question comes to us from Nate. And this is a question I'm sure we're going to have a lot of dialogue about in the months to come. It has to do with purchasing something and vaccines. So Nate's question is it legal for a venue to require proof of vaccine in order to attend a concert if you've already purchased your tickets? Lorelei, what are your thoughts on that?
I think it probably is legal. I think it is. I think I'm sure there's some fine print somewhere on the back of that ticket that is going to protect that venue from this sort of situation. Now, the venue is likely some sort of a private facility and their business. And so they probably have the right to protect their employees and the people that come on their premises. And I think that's the right thing to do, to try to protect everybody accordingly. Now, I think some places are requiring, in lieu of a vaccine, maybe a negative test result. And so I think that might be a loophole as well. If they can offer an alternative to the vaccine, then that's a possibility for them to stay open and keep everybody on the premises still.
Oh, that's a good point. That's a good point. Harry, any thoughts on this? Because I can see this becoming an issue with some folks.
Yeah, and I agree. When you purchase your tickets, usually a lot of people nowadays do them online. There's always, if you really look, no one bothers to read it, but there's always these catch-alls about how, something's always subject to change based upon certain weather whatever. I'm sure this falls in one of those categories that, they have the right to do that. I don't see how they would not have the right to do that. But read the fine print. You'll be surprised what's in there that you don't even know when you make it just like that. The things
That's
that are
a
in
good
there,
point.
or if you get hurt, if it's a sporting event, things, they're not responsible if you get hurt, by say, if you're at a baseball game, a ball that goes awry or a bat or something. By the way, you can still get around some of those. That's a whole other topic, but you'll be amazed at what is on the back of these tickets or what is in the fine print when you purchase them, if you actually take the time to read them.
Yes, indeed. Yes,
Yeah.
indeed. I've come across some strange stuff myself.
Yeah.
Our next question comes to us from Derek, and his question has to do with an injury. A football injury in exact. He says, I had a fall at work and it hurt my neck and the back, and he's in serious pain. But he also had a neck injury from football 22 years earlier, but had no problem since then. Will insurance try to say that this is a pre-existing condition and not try to cover it? How do I handle this? Now, Harry, I want to ask you this question because I know you both are personal injury attorneys, but this term pre-existing condition, it seems like a lot of times it's slapped on a lot of things that insurance companies don't want to deal with.
Exactly. If the insurance company can show that you had a pre-existing condition, obviously it lessens the damages that they would have to pay out, because they'll say you were already suffering from a particular condition. So they would always love to be able to say you're already suffering some prior back problem, neck problem, whatever it is. In something like this, you'd have to show, and a lot of people play sports or they have activities when they're younger. It's so far in this particular instance, it was 22 years ago. Going through medical records, you can show basically what your condition was, that it had healed, that it was over with, that you had already healed from that injury. You weren't suffering any problems from it. And so in this particular instance, it would be a new injury, because this accident would have caused essentially a new injury, not exacerbated, what they call an exacerbation of a pre-existing injury. But there are some gray areas where someone does have an issue going on, and then might have some back issues. They get into an accident and it makes it worse. You can show that through doctor's testimony, medical records, whether or not you're actually suffering and whether or not it was still in existence, or whether or not it had healed and it was a brand new injury. But they will certainly try to do that. You're correct.
Okay. Lorelai, any thoughts on that?
No, I agree with that. I think they are going to try whatever they can to not pay a claim. And it's possible that you could be injured and it could aggravate something already there. There's laws in place to protect people from situations like that. So we learn about it in law school. It's one of everybody's favorite rules, but the eggshell skull rule, which basically says you take your plaintiff as you find them. And so if their injury occurs, but yet they already had that crack in the eggshell, then you can still be responsible for the additional injuries.
How far back can medical records go? I mean, in his case, it was 22 years, but so how far back, Harry, can you go? I mean, childhood, maybe? I mean, how far back can you go?
I think it all depends on what the injury that is being claimed. And, for instance, if someone has a condition that they've had on and off their entire life, and they put that issue in their case, they kind of open the door for the other side to ask questions about it. But if it is so far removed and really it can't be connected to the old injury from a new injury, they can't just go back and do a fishing expedition. A lot of times we get into fights and battles about when they want to give us medical authorizations to sign on behalf of the clients. A lot of times we'll limit those, or we'll make an objection saying it's so far out of time that it's not relevant to the case at hand. All they're trying to do is stir the pot and come up with something so they can try to put on a defense.
Okay.
There's really no like right line, I guess is what I'm saying. It all depends on the situation.
Gotcha. Very case specific. All right, let's move on to Trey's question. Trey has a question about signing documents. This is very important. Once I reached an agreement with an insurance adjuster, can I trust signing their release form? And how much would a lawyer charge just to take a look at the paperwork to see if it's even legal? Lorelai, you want to take a stab at this one?
Yeah, part of me wants to give the insurance company the benefit of the doubt at that point. If they have made an offer, in my personal experience, the settlement releases are pretty standard across the board. But I would say nearly every single release that I receive from the insurance company, there's something in there that I make a change to before I allow my client to sign it. And so it is a legal document, just like we talked about the fine print on the back of the tickets. You do need to read every single word, and the words have very specific meanings that could change things or cut your rights off in the future. And so I would suggest having an attorney read over a release before you sign it. Now, in terms of how much to charge, I think that depends on how specific it is.
Oh, okay. That's a good point. That's a very good point. We have to be specific. And of course, if they need a consultation, they can contact either one of you, Lorelai Harris at Porter and Maloof and Harry McCumber at Morgan and Morgan. Hey, listen, I'll be back in just a moment with more of their questions and answers. We got some good information tonight. Ask Us Anything is the topic. I'm Morgan Dukes, and this is Law Call. If you have further questions for Ms. Lorelai Harris, you can find her here in Jackson at Porter and Maloof. The phone number is 601-957-1173. And you can also find her on the web at www.portermaloof.com. If you have questions for Mr. Harry McCumber, you can find him here in Jackson as well at Morgan and Morgan. The telephone number is 601-503-1654. And of course, you can find Morgan and Morgan on the web at www.forthepeople.com. Both of these wonderful personal injury attorneys are with us tonight discussing anything. And we have had questions from people all across the area that have asked us anything. So let's get to Kimberly's question. She has a very good one. A lot of people have wondered about this. And her question says, if I'm told that there's not enough evidence to take my case, should I get a second opinion? Lorelai, what's your thought on that? Because I know a lot of people feel like, I don't know, I've been rejected here. Should I keep trying or not?
Yes, the answer is yes. And I would say a second, maybe even a third. If you feel strongly that that you have a claim or a right to a legal issue, then absolutely. Get a second opinion, get a third opinion if you need to. A lot of times you'll find that the first attorney you may have reached out to just doesn't deal with that specific issue. And so there might be a better attorney out there that can spot it and see it from a different point of view and may be able to jump in. I think resources might also be an issue depending on who you reach out to. Different attorneys have different resources that allow them to handle cases that others may not be able to.
Okay. Harry, any thoughts?
Yeah, I can tell you there's a lot of cases that I've taken that other attorneys have rejected for various reasons, and we're able to have a great successful outcome. On cases that I don't necessarily take for various reasons, I encourage the client to get another opinion. And I kind of explain it. It's like going to a doctor. Sometimes you go to one doctor and they have an opinion, and then you follow up, get another opinion, and then the doctor says something. You might go to a different doctor and he has a different train of thought. It's no different. So always get a second opinion. Always.
I like that. I like that. All right, then. Well, hopefully that helps Kimberly out just a little bit. Let's move on to our next question. It comes from Carlene, and she wants to know, how long does it usually take for an injury case to reach a settlement in court? And how do most people manage to keep the medical bill collectors away until everything is decided? Now, come on, Harry, give me a good answer to that question.
Well, and it does depend on what kind of case it is. Some cases or involve more work or more complex than other cases. So there's no set answer. You have to remember, usually when there's either a car accident or someone, it could be a trip and fall or anything like that, there's going to be a period of time where the client has to receive medical treatment. And so there's a treating period. And then you also want to make sure to see if they're going to need any follow-up. So you don't want to rush a case, because if you try to rush a case and settle it, and that you sign the release and the case is over, and the person finds out they've really had more extensive injuries, they can't come back and reopen the case. So there's a period of time you want to make sure that they've adequately recovered. And then depending on how complex, some cases you may settle out of court, other cases you may have to put in litigation, file the lawsuit. And then you have to do what's called discovery, which is the taking of depositions of the parties involved, of witnesses, and then potentially expert depositions. You got to get the doctor's testimony. There's a period of time to collect all the bills and all the records and the lost wages to put together the damages. And then, of course, you're on a trial calendar, depending on what court you're in. And so there's a lot that goes into how long it will take. Certainly, you want to make sure that whoever your attorney is working your case forward and not letting the case just sit there. And one of the things I like to do is put the case on what's called a scheduling order. Whether or not the court mandates it or not, I like to go ahead and get an agreement from the other side as to when certain things are due to make sure that the case is progressing along. Lorelei, what are your thoughts on that?
No, I think you're absolutely correct. And I love a scheduling order. I think it puts the deadlines. So the judge is on board, the judge signs off on that order. The other party, the defendant is on there as well. So
I love it. So it just all works out then. Well, listen, Lorelei, thank you so much for being here. And Harry, thank you so much as well. This has been good. And of course, if you have further questions for them, reach out and give them a call. I'm sure they can give you all the answers that you need. Thank you both for being with us tonight. And from all of us here at Law Call, we bid you a good night, and we'll see you next time. Good night.